Hello everyone, this is a tutorial clip from CSP on the subject of contract law, first year, semester 2, LB101 on the midterm exam. And this is for Sec 2. I won't be covering too much details about what we learned, but maybe some essential elements, basically making some short summaries of each topics. And I won't be covering the details of file 1 to file 3 since the professor won't be putting that on the exam anyway, so only will be the details of file 4 to file 8. So let's start with the first one, which is hidden intention. So the sections 154 state that any declaration of an intention, even though the declarer does not intend to be bound by the intention so declared, does not render such intention void, unless the other party has the knowledge of the declarer's hidden intention. This means that, for example, if A wants to be bound by contract A, getting bound to contract A. But what he expressed or he's declared out loud is that he wants to be bound by contract B. And this is a genuine intention, or it also called inward intention. And this is a outward intention. This is not genuine whatsoever. But because A expressed this contract B instead of contract A, so if A is making a contract with B, B would understand that A wants to make the contract B, not the contract A. So even though the law wants to uphold A's genuine intention, but because A only expressed his outward not so genuine intention, so the law has to protect the contracting party by upholding this contract instead, even though the law wants to uphold a genuine intention. So that means that even though A actually wants to be bound to this contract, does not mean that this one will be void, because A only said things about this one but not this one at all. But as long as B or the contracting party know about A intention to do this one, then even though A made this as an outward intention, if B know that A actually want to do contract A, then this one is not void. This one is not void no more, and this one will be void instead, because this is fictitious intention. A don't actually want this, and this is just outward intention. And if B know of that, then this one will be void, and this one, the law will uphold this one. Moving on to the second topic of fictitious intention. So A act in connivance with B to deceive C. This is the concept. So normally, because A and B both know what JA they are making, their actual intention, they know everything about each other, then because their contract between each other is genuine, that means the contract between them is not void, even though they are deceiving C and C does not know of their contract. But their contract is not void because C is not a contracting party in this contract, and C not knowing the inward intention does not make this contract void. And because the law wants to uphold the genuine intention, so the law does not matter with anything else but if both parties know what they are doing. But whenever this is invoked against a third person who does know nothing about the contract that they are making here, and who is acting in good faith and injured by the declaration of such fictitious intention made by these two, then that means that the law would protect D, who is a third party. It not necessarily mean that contract between A and B is not void, but it just means that the contract between A and B of fictitious intention cannot have anything to do with D. So if D has entered into any contract that relating to their business, D got to keep everything about the contract, like everything he got out of the contract as well. And that's basically the concept of fictitious intention. And moving on to the next topic, which is about the fictitious intention with a view to conceal another juridical act. This one is similar to the second topic, which is about the fictitious intention, but this one is more focused on the fact that a declaration is made in order to specifically conceal another JA. So we have a little example here, which is like we have two JA. One is the concealing JA and one is the concealed JA. So the concealing JA is the gift contract and the concealed JA is the deposit contract. So this one is the outward intention to kind of like deceive other people, but this one is like genuine. So as long as A and B know what they are doing and what contract they want to be bound to, then this one is void because they know each other's hidden intention, right? And this one is upheld. Yes. So it's kind of similar to the previous topic, but we have a little bit of the addition here. So in section 155, paragraph 2, it is said that if the declaration of a fictitious intention under paragraph 1 is made with a view to concealing another juridical act, the provisions of law relating to the concealed juridical act shall apply. So in this case, because this one is void, this one is a gift contract, this one is void, but this one is upheld. So this one conceal this one. When this one is upheld, then that means that everything has to be done according to the law relating to the deposit contract. So B has to keep the car, like if A deposit this car to B, then B has to keep the car, not take the car like how he would in the gift contract. So if this concealed contract is being upheld, then the proceeding, everything has to be done according to the provisions relating to the deposit contract. So that's kind of like about it. And also the protection of the third party is the same thing as already said in the paragraph 1, which is if the party is acting in good faith and also injured by the fictitious intention, then the JA may still be void, but it cannot have any effect on the third party because the third party is protected under section 155. Yes. So that's kind of like about it. Which is fraud or contortion. The legal provisions relating to this topic is section 159, 163, 176, and 162. A fraud happens when a party deceitfully making a false statement or purposefully conceals some crucial fact about the contract from the other party. And the other party, the one that got deceived, would not have made the JA from the first place if he knew of the fact. So there are two different forms of fraud. First is an active form, which is when a party purposefully said or conveyed deceitful crucial information. And this is also called general fraud. And the second form is the passive form, which is when a party purposefully conceal, hide, or avoid giving crucial information of JA in order to deceive other party by blinding them from some information that they ought to know. And this is called fraud by silence. Here is a little examples as to how fraud works. So in this scenario, A is selling B a cookie which contains dairy products like egg, milk, etc. And in order to sell the cookie, A deceives B that the cookie is vegan, when in fact the cookie is not vegan because it is made out of dairy products from animals, so it is not vegan. And A deceives B by making a false statement, which is an active form of fraud. And after B listened to A, B mistook that the cookie did not contain any dairy products and is vegan, so B bought the cookie. And if B had known of the fact that the cookie was not vegan, then he would not have bought it in the first place. So this means that the declaration of intention of B would be voidable under fraud. And there is a possibility that the principle of fraud and the principle of mistake overlap. So in that case, the injured party may choose the doctrine which best benefits him. But if the party is mistaken with a fraud, just mistaken by maybe miscommunication, then the case will fall within the principle of mistake only. But they would overlap when a mistake is caused by fraud from the other party. And in that case, the injured party may choose as he likes. Move on to the fraud by both parties. Fraud by both parties mean that neither of the party were saying the truth when they were saying the truth when they were making contracts. So this means that neither party may allege fraud on the part of the other party for avoiding such act or claiming any compensation at all. So they both cannot avoid the contract or claim compensation of any damages because they were both liars, they were both dishonest about the contract. And fraud by third party is that if a party that declare his intention on the account that he heard some deceitful saying from a third person, the declaration of such intention will become voidable only when the contracting party knew or should have known of such fraud. So like this example here, if B have another friend which is C, and C is the one who recommend B of this cookie and said that the cookie is vegan, while A didn't say the cookie was vegan, it's the B friend C who told B that the cookie was vegan. In that case, because B and C is friends with each other, A did not know of the existence of C at all. In that case, the contract won't be voidable. But if C has planned with A before deceiving B, and A actually known of the fraud that C is saying to B, then the contract will be voidable. Essential fraud happens when fraud is committed only for a party to accept more onerous terms. So the deceived party would have entered the contract anyway, even while knowing the fact. So we can have a little example over here. So if B can have both vegan cookie and normal cookie, then we would have to buy A's cookie anyway, even though the cookie was not vegan. But because A thought that we only eat vegan cookie, so he told B that his cookie was vegan, and in fact his cookie was not, because it made out of dairy products. But because in fact B would have bought the cookie anyway, even though he knew back then that the cookie was not vegan. So in this case, A actually deceived B, but because B would have still bought the cookie even though knowing that it is made out of dairy products. So in this case, it is called incidental fraud, and B cannot then avoid the contract. But B may claim compensation for damage resulting from such fraud. For example, A will sell cookie vegan for 70 baht, but for his normal cookie, he would sell the cookie for 30 baht. Because B will have to pay more for the vegan cookie, so maybe if B want to raise the issue, he can claim compensation for the other 50 baht that he lose for buying so-claimed vegan cookie instead of normal cookie. So that's the concept of incidental fraud. And moving on to the topic of duress. Duress happens when a party is threatening the other party and leading them into making a declaration of intention which made under fears or duress. In section 164, the just states that the declaration of an intention under duress is voidable, and duress which renders an act to be voidable must be one which causes a danger that is both imminent and severe, that is led the threatened party to be in fear, and without those fear, such act would not have been made. So basically, the threatened party would be in fear so much that they would make a declaration of intention that they did not mean to make, and without those fear, they would not have made that declaration at all. And because the nature of duress is just more dangerous than fraud, duress by third party is also voidable, because we see in fraud that the false statement made by the third party is not voidable if the contracting party is not known of the fact that there is a third party making false statement. But because duress is just more dangerous, the nature is just more serious, the duress exerted by a third party means that the declaration of the threatened party becomes voidable instantly. And it does not matter whether or not the contracting party know of the third party's duress. And there is something in English law called referential fear also that the professor did mention in class, that referential fear is taken into consideration to determine whether or not a JA is voidable under duress in English law or maybe in other common law system. Referential fear is the fear of the position of the other party, for example, a dynamic between the boss and the employee. So naturally, the boss would have more power and authority over an employee. So this person will suffer more in fear when they declare their intention, and that means that their intention might not be from their free will. So that's why in English law it is just more strict than Thai law, because in Thai law the concept of referential fear does not exist and is not amount to something made under duress. It is stated in section 165 that a threat to resort to the normal exercise of a right is not regarded as duress, and any act carried out on account of referential fear is not regarded as an act carried out under duress as well. The normal exercise of a right is also when a person make threats about the actual legal consequences about something, about maybe the consequences of a JA that both parties made previously. If one party make threats about the actual legal consequence, then it is not amount to something that made under duress. So the declaration of intention of the threatened party will not be regarded as something made under duress, and thus not voidable. But in English law, it's just more serious. So which leads me to the topic of referential fear leads me to this relating topic, which is also a concept that exists in English law and other common law systems, which is the topic of undue influence. Undue influence is when a party abuses power to the contracting party to kind of gain some kind of benefit from the contract. And the result is that the declaration of intention made by the threatened party or the party with lesser power becomes voidable. We have a little examples over here to compare between English law and Thai law. So here A is a phone owner, he has a phone, and B is a thief. So one day B stole A's phone, and then A kind of finds out later that B is the one who stole A's phone. So now he is demanding that B return back his phone, but because B lives in poverty and he has to sell the phone for the money, so now he can't recover the phone anywhere because the phone has already been sold. Now because A is without phone right now, so A is making threats that he will be pressing legal criminal charge against B if B doesn't buy him a new phone with the same model. So now B is buying a phone back to A. So he declares intention to buy A's phones back. Now in Thai law, what the threat that A is making is not count as a threat of duress. So basically, the B declaration of intention is not amount to a declaration that made under duress, because in Thai law, A is just exercise his normal right that he will be pressing legal criminal charges against B, and A has every right to do that in Thai law. However, in English law, it's just more strict. So because A definitely has more power over B, this party here, so now maybe A is abusing his power to get B to declare his intention to buy this phone, and it might be amount as a JA, as a declaration made under duress in English law. In the past, due to the doctrine of duress being underdeveloped, the doctrine of undue influence was made to help the threatened party or the lesser power party. But now with the development of the doctrine of duress, both doctrines can overlap on the same case. So maybe undue influence and duress may be overlap in the same case, because now that duress is just more large than it used to be, now it may also fall under two grounds. And this is the undue influence. Is when a party actually has more power over the other because of what was happening. But there is also something called presumed undue influence, which is a presumption that one party has influence over the other party and would naturally exert their power over the other party. And the result is that the declaration of intention made by this party will become voidable unless this party successfully rebutted in court that they have no influence over this party. Because it is just a presumption, it's not actual thing that's happening, but the law will presume that this party has influence over this party because of something called special relationship. So these are this example of the special relationship that will make the law assume that one party just has more power over the other. So the relationship between lawyer and a client, a relationship between a parent and a child. So because the dynamic of these parties, the law assumes that these parties have more influence over this party. Because naturally, the client would listen to lawyer and a child would listen to his parents. So it is natural to assume that one party would have more power over the other, and then the declaration of intention made by these parties under supervision of this party might not have been from their free will, from their own free will, and might not have been because of the pressure, because of how much this party has, how much influence this party has over this party. But it's just a presumption. It's just different from undue influence, which is the actual power that one party has over the other because of what was happening, because A is a phone owner who definitely has more authority over B because now he can press legal charge against B. And come back to duress, because Thai law has nothing similar to referential fear or something like undue influence. So there is a section that might make the threatened party has more advantage when they are in court. Is the section 167? Is that in determining a case involving mistake, fraud, or duress, regard shall also be had to the gender, age, position, health, and mental condition of the declarer of the intention, and other circumstances as well as surroundings pertinent of the act in question. So this section is just include into the law that to determine that a party is under duress, under fraud, under mistake or not, it shall be include into the consideration their age, the gender, position, health, and mental condition. I think this is the closest we have to the concept of referential fear or undue influence, because we don't have that kind of concept in Thai law. But if we count as to the position, the age of the parties into how we determining that the declaration is made under duress or not, then that might be what we use instead of the concept of referential fear or undue influence to help a party. Next is the concept of mistake. So a mistake happens when a party misunderstanding some crucial facts about a JA. So that means that their intention is not genuine and not from their free will and not actually the inward intention they have, because they're just mistaking about the JA. So there are two types of mistakes. First is a mistake as to the essential elements of a JA, which will render the declaration of intention as void. And the second one is the mistake as to a quality of a person or a property, and that will render the declaration as voidable. The first one is the mistake of an essential element, subject matter of a juridical act. So the elements have to be a fundamental elements of the contract. Section 156 does give us some example as to what kind of elements are counted as essential. So first, the nature of the contract. If a party is mistaking contract A for contract B, that means he is mistaking the nature of the contract that he is making, and that means that the declarer's intention is void. The second one is person. Maybe the declarer grabbed the wrong person with the same name, and that means that the contracting party is not the person that the declarer actually wants, so that also makes the declaration of intention void. The property, which is the object of the contract. So if the objects actually different from what the declarers had in mind, then the declaration of intention of the declarers also become void. And there are also other elements that are crucial to the JA, like price and other things. So these are just examples given by section 156. So, but they can be other crucial elements as to the matter of JA as well. The second one is mistake as to a quality of a person or a property. So this happens when a party mistaking a quality of a person or a property, and that it has to be a important quality that if the party has known from the first place of the quality of the person or property, then he would not have made a contract at all. And I will make some example here. So if A want a translator, A go to B, who is known to speak many languages. The languages that B speak are Thai, English, and Korean. But A want to hire a translator that can translate Chinese, Mandarin Chinese. But A thought that B can speak Chinese. But B can't actually speak Chinese because he can speak only Thai, English, and Korean. So now A is mistaking B quality. And if A has known from the first place, then A wouldn't have hired B in the first place. So that means that A declaration of intention becomes voidable. And the avoidance of JA, we have to go back to the section 176 about rule of restitution. So when a party avoided a contract, that means that the party shall be restored back to their original position, and if it is impossible, a party are entitled to damages in compensation. Moving on to gross negligence. This is the last type of mistake which is incapable of any remedy. This is a mistake made by a party on his own negligence, his own carelessness. Thus, when a party fails to exercise even a slight bit of care about the contract at all. So the person declaring an intention, such person may not avail himself of such mistake in his favor. So the party basically, the declarer of intention basically cannot invoke the contract. The next topic is the declaration of intention and time effectiveness of the declaration of intention. The legal provision relating to this topic are section 168 and 169. So there are two types in Thai law. Yeah. So first is instantaneous mode, which is in section 168, and second is non-instantaneous mode, which is in section 169. This one is a perception rule and this one is a receipt rule. The law is very long, so you all can read it yourself to understand more about it. But basically, instantaneous mode is that a person needs to be in the declarer present for a declaration of intention to fall under instantaneous mode. At the time that an intention becomes effective is when the person has knowledge of the intention. And we have some example here, which are first real-time conversation. If we are talking from in real life and without talking through any technology, any phone calls, any video calls, this is real-time conversation, will be fall under instantaneous mode. And if the conversation, the declaration of intention is being declared in a video call that both parties are present at the screen, then that will also fall in instantaneous mode, because both parties are at each other present. Second is telephone call. If both parties are responding to each other immediately, then that means that both parties are also in each other present. And instant messaging. Instant messaging can be both instantaneous and non-instantaneous. So have to be careful about that. It can be instantaneous when both parties are present and responding each other immediately. It like text message. Instant messaging is like text message. And when they declare an intention or accept an offer, sign the contract or agree on entering the contract, if they both are present and responding to each other over the text, then this fall under instantaneous mode. And the second one is non-instantaneous mode. This one is that both parties are not in each other present. So this means that there can be no immediate response. And the time that an intention becomes effective is when the person receives the message or intention. So this can be email, because our party might open the email later or something. So it's not immediate. Fax also. And letter is when the intention becomes effective when the letter arrived at the receiver house, because that means that the receiver received the message if the letter is being put down at the receiver house. But this is Thai law. So in common law though, when the letter was posted is when the intention is being made. Is when the intention becomes effective, is when the letter was posted. So it's not the same as the arrival of the message. And instant messaging as well, when one party or both parties are not present at each other's screen, that's when instant messaging become non-instantaneous mode. That's when they might not be at each other present, but they are not responding to each other immediately, and it takes time for them to look at the message, then it's not instantaneous. An intention is effective when a person receives a message. And receive a message in this meaning is when the information entering into the receiver information system. This is from the Electronic Commerce Law in 1996 and also had the same meaning in the Convention of Electronic Communications in International Contracts of 2005 as well, because in this convention it also states that the intention is being received when it is capable of being retrieved by the addressee or the receiver, basically. So if a message is being capable to be retrieved by the addressee, it's probably when the information enter into receiver information system. So these are basically the same meaning or similar meaning, just from different law. Revocation of the declared intention in non-instantaneous mode. The law provides two fixed times in which the original declaration of intention will become ineffective. First one is that the revocation of declared intention is received before the declaration of intention previously made. The second is that the revocation of declared intention is received at the same time as the declaration of intention previously made. And the law also adds that if a party dies or adjudged incompetent, quasi-incompetent by the court after the declaration of intention being made, that does not make such declaration impaired or ineffective. So even though a party dies or become unable to do judicial act anymore, the declaration of intention that being made before such condition is still effective as normal.